you hear me? Great, thank you. I want to make one quick announcement. I'm supposed to inform everyone that this seminar is being recorded and it will be published for future reference afterward on webex.com. I'm going to be covering the first hour, which is going to be an overview of sentencing from 1:30 to 2:30, and then there will be a Assistant District Attorney from Lehigh County who will be covering the appeals section for the second hour. So I want to thank you and welcome everyone. Feel free to submit questions as I go through the various slides. I will try to answer your questions verbally. I will not be typing in responses. If the questions come in too fast and I'm not able to address them, or if they're too specific or I'm not quite sure what you're asking, you may need to contact me after the webinar and we can certainly do a follow-up sometime later. Thank you. What I want to cover for the majority of the hour is really just provide some sentencing overview, really the fundamentals that courts are working with when sentencing an offender. I'm going to give you a very general overview of the sentencing guidelines and how they work. I know in your webinar announcement it was advertised as current issues. There's always current issues in sentencing. What I'm going to try to do is highlight some of the changes that have been adopted in the last year or so. Some are very, very technical, but I will try to just give you sort of a general overview of what those updates would be. We will be doing a follow-up webinar, what they're calling Part 2, later on this year. So if there's specific questions that I don't cover today, feel free to submit those to me afterward, and I can cover those in the Part 2 webinar. So I'd like to begin with the fundamentals. And there's three main things that you need to think about when we're discussing sentencing. First is the classification of crimes, and that's really determined by our legislature, and that will determine the longest sentence that's permitted, and that's based on the grading of an offense. We also have mandatory minimums. They're also a creation of our legislature. They're going to determine the shortest minimum sentence that a court can impose. And then in addition, we have sentencing guidelines. And those guidelines are going to provide minimum recommendations to the court. I'm going to go into each one of those in a little bit more detail as we move through. So beginning with classifications, offenses are generally classified into the various grades. We have misdemeanors, we have felonies. Some are further subclassified into various degrees, first degree, second, third degree. The crime of murder is classified separately in statute. So when you think about the classifications and the various degrees and what is the longest maximum sentence that's permitted, this is what our legislature has established. Judges have to work within this framework. So for example, if you look at the areas that are circled in red, if somebody is in court today and they're convicted of a felony 1 offense, let's say for example purposes it's a felony 1 burglary, the judge can sentence a person up to 20 years for that felony 1 crime. They can certainly sentence to something less, but they cannot exceed that statutory maximum for that grading or classification of that crime. We have various maximums for the different grades. You'll see various misdemeanor maximums down to summary offenses. You'll see some other crimes toward the top of the table where we have murders. Some of those are governed by mandatory penalties. You'll see something on the chart that says inchoate murder. Inchoate crimes in Pennsylvania or criminal attempt, criminal conspiracy, or criminal solicitation. So if someone is convicted of an inchoate murder, it would depend on whether or not their serious bodily injury would determine the maximum penalty for crimes like that. Then you'll see a few other crimes just below that. Although they are graded as felony ones, our legislature has said that there are certain circumstances for those crimes. For example, in those sex crimes of rape and involuntary deviant sexual intercourse, when there is a young victim, it depends whether or not there is serious bodily injury. So a court could actually punish up to 40 years or even life for convictions with those circumstances. In addition, if a court is thinking about locking someone up, confining an individual, in Pennsylvania, courts have to impose a minimum term as well as the maximum term. The minimum in Pennsylvania on a confinement sentence is going to determine when that offender is eligible for parole. Parole in Pennsylvania is not automatic. Parole is an earned privilege. It's a conditional release from an institution. Somebody can be released from a county jail on parole, or they can be released from state prison on parole. But parole does not happen automatically in Pennsylvania. So if a court is imposing a confinement sentence and they're required to state a minimum term as well as a maximum term, there is a rule in place, it's actually in statute, where it says that your minimum period of confinement cannot be more than 1/2 of your maximum sentence imposed. So for my example with a felony 1, if a judge wanted to lock somebody up for the longest period of time possible, it would be a 10 to 20-year sentence. Okay? That would mean at 10 years, the person is eligible to be paroled, but their sentence is truly 20 years. It's a 20-year sentence. So if we know all of the maximums for the various classifications or gradings of crimes, what are some of the sentencing alternatives that courts can impose when sentencing an individual? There are only specific ones identified in statute. Some of them you may be familiar with, such as an order of probation. We've already discussed confinement. There's some intermediate punishment. There's something called county intermediate punishment and state intermediate punishment. Fines and restitution have been around for a very long time. Statute allows courts to impose one or more of these alternatives. So a court could impose a fine on an individual, restitution, as well as a term of probation. Or a court might impose a confinement sentence in addition to a period of probation. They have the ability to sort of impose not just one but multiple sentencing alternatives. Things you do not see on this list are things like electronic monitoring, treatment, whether it be inpatient treatment, meaning residential treatment, community service, treatment courts, drug courts. They're not sentences. Those are simply programs or a condition of someone's sentence. So just because somebody is participating on electronic monitoring doesn't tell us anything about the sentence. Was that individual directly sentenced to a term of probation? Were they sentenced to county intermediate punishment? Or were they sentenced to confinement? And as a condition of that sentence, they might be on electronic monitoring for a certain number of days. So it's very critical to know what the direct sentence is, not simply what are the conditions of that sentence. What I'd like to do is just spend a few moments on some of the more common alternatives, make sure everyone understands who they're intended for and how the courts would impose those direct sentencing alternatives. An order of probation is intended for individuals who really haven't caused any harm. They're unlikely to commit another crime. They really have been pretty much law-abiding. These are individuals who should be sentenced and placed directly out into the community. Someone would not be going to jail or prison on a term of probation. When a court orders probation, it's a flat term. and the term of probation cannot exceed the statutory maximum for the grading on the first chart that I displayed. So when a court imposes a flat term of probation, for example, an individual is convicted of a misdemeanor 2 conviction, and say the court imposes 2 years of probation. On that term of probation, they could order that the offender participate in community service. Maybe the offender has to get their GED. Maybe the offender has to get a job and maintain employment. So the court can place various conditions upon an order of probation. If a person would violate any condition of their probation, what happens is the probation department will notify the court of that violation, and they can schedule a revocation of that term of probation. So when that offender comes back before the court, the judge can revoke probation, and they can impose a brand new sentence. So on a revocation of probation, the court has all sentencing options available to them as they did at the original sentence. So if the court really wanted to, they could impose another term of probation. But what we typically see is a judge might impose a harsher sentencing option if somebody violated that term of probation. Several years ago, back in the early 90s, our legislature enacted another sentencing alternative. It was called county intermediate punishment, and what our legislature intends county IP for is for individuals who would otherwise be sentenced to a county correctional facility. So the offender standing in front of the court is thinking about confinement for that person, and they would really end up in a county jail based on their conviction offense, based on what the sentencing guidelines recommend. So the judge would be looking at this offender and thinking about some type of sentence that might be in lieu of what they would otherwise have been serving in the county jail. But in statute, under county intermediate punishment, our legislature was very specific on who can get a county IP sentence. There's probably about 15 to 20 offenses that are fairly violent crimes that could never receive a sentence of county IP, nor could one of those offenders ever have one of those convictions within the past 10 years. So those lists of offenses would determine eligibility based on their current offense or prior convictions within the last 10 years. And keep in mind, it's somebody who would have otherwise gone to county jail. So it's not probation, and it's not confinement. It's somewhere in between. Now, county intermediate punishment is a flat term similar to probation in that the court just imposes this flat term that does not exceed the maximum for the grading. They're not imposing a min because it's not confinement. Therefore, parole is never involved with county IP because it's not confinement. But when the court imposes this flat term of county IP, they break it into two pieces or two components. There is a restrictive component, and we call that RIP, and there's a restorative sanctions component. Those types of programs for specifically restrictive intermediate punishment, these are defined as programs that would house an offender full or part-time, restrict movement, and monitor compliance. These examples of RIPs could be things like electronic monitoring, any type of residential or inpatient treatment facility, halfway houses, day reporting, house arrest, intensive supervision. These programs are the programs that would encompass the part that of the county IP sentence that would be in lieu of confinement. So if the person standing in front of the judge is sentencing and the judge was thinking about locking somebody up for a minimum term of confinement of at least, for example, 3 months, but the judge is thinking county IP might be a better option for this person, they're nonviolent, and maybe they really don't belong in county jail, the court could be imposing county intermediate punishment for a flat term, And now they're looking at 3 months of restrictive because that's the part that they would have otherwise confined that individual. So that 3 months might be one program, or it might be a combination of programs. You would start with the most restrictive program, stepping the person down. So maybe they might start with electronic monitoring for a month, then maybe phase the person down to house arrest without any equipment, just on intensive supervision for 2 more months. So that would be 3 months of restrictive programming under a county intermediate punishment sentence. The balance of a county IP sentence is on restorative sanctions programs. These are just the opposite of something that would be considered restrictive. They could be programs such as community service, fines, restitution programs, and just general probation supervision. Don't think of it as probation as a direct sentence, but it would be just general supervision as the balance of county IP, or the non-RIP component. Now, if a person would violate at any part of their county intermediate punishment sentence, they're brought back before the court to have that sentence revoked, and the judge can completely resentence. So they have all sentencing options available to them as they did at the original sentence. It doesn't matter where they are in that sentence, whether they're in the first week or the final week before they max out on supervision. More likely than not, what we typically see when judges revoke a term of county intermediate punishment is they're going to resentence probably to a term of confinement, but there are some other options that they might want to consider. They normally would never go in reverse and give a less serious sentencing alternative. So then we would move on to state intermediate punishment. State intermediate punishment is fairly new to the courts and in statute. It was enacted back in 2005. Some counties use it a lot, so you may be somewhat familiar with it. Some counties don't use it much at all, and some counties have never used it as far as the courts imposing. But state IP is intended for somebody who would have otherwise been sentenced to a term of confinement in a state correctional facility. The difference here with SIP is that the individual has to be assessed to have some type of dependency on drug or alcohol. So they absolutely must be drug or alcohol dependent before they could be sentenced to a term of state intermediate punishment. Really what happens here is the district attorney is holding all the cards, and that they have to give their approval or their recommendation that they would be in agreement to a state IP sentence before the court could ever impose such a sentence. So the DA would say, yes, we would think this would be a good candidate. We think they have a drug and alcohol addiction. The offender would have to go to the Department of Corrections prior to sentencing to have this assessment conducted. And if the assessment comes back and they say, yes, an individual has drug or alcohol addictions, everybody would be in agreement, meaning the judge, the prosecutor, and the defense attorney, and then the judge would simply say sentencing that individual to 2 years of SIP. That is the amount of time. The court does not impose less or more. It's a flat 2-year term. Regarding state IP, there was a recent amendment in statute. It was amended this past September. And what it did was it permits the prosecutor to waive any ineligibility criteria because state IP is intended not only for somebody who's drug or alcohol addicted, they also have to be nonviolent. So similar to county IP, there's a lot of offenses that would deem someone ineligible. But now what can happen is the prosecutor can advise the court if they want to waive the eligibility requirements if the victim has been given notice of the prosecutor's intent to waive and be given an opportunity to be heard on the issue. The court, after considering victim input, could refuse to accept the prosecutor's waiver, or they could accept that waiver. If you're interested in a little bit more information regarding SIP in your specific counties on how often sentences of SIP are imposed, you can look on our website at the Sentencing Commission or the Department of Corrections website. Each of us conduct an annual review, and there are statistics based on every county. Well, if the individual is not sentenced to probation, county IP, SIP, probably the more common alternative is confinement. Our legislature has said that confinement sentences are intended for people who are probably going to commit another crime and they need to be locked up in an institution. Keep in mind that confinement sentences, the vast majority of confinement sentences require a minimum term as well as a maximum term. And they have to follow that rule where your min cannot be more than 1/2 of the max. There are some exceptions related to min-max on confinement. One of them relates to summary offenses, the very minor types of crime. Summaries are only punishable up to 90 days, and there's a specific section in statute that says summaries do not have a right to be paroled, so a judge can impose flat confinement on a summary. There is another exception, but it's pretty technical, and it regards what we call a split sentence. And I can tell you that most counties don't use it. There's a very, very small number of counties that utilize it, and it involves consecutive county intermediate punishment. But if somebody was sentenced to the traditional min-max term of confinement, keep in mind your minimum determines when they're eligible to be released on parole. So, for example, if somebody was sentenced to a term of confinement of 6 months to up to 12 months of confinement, at 6 months they would be eligible for parole. If they are paroled and then they're out on parole for the next several months, they're placed various conditions upon that parole supervision. And if that offender would violate any terms of their parole, they can be brought back. If it's a county sentence in front of the judge can revoke parole, but you cannot resentence on a parole violation. The original sentence always stands, and all the court or the Board of Probation and Parole can do is recommit the offender for the balance of the unserved term. So for my 6 months to 12 months example, if somebody got paroled at 6 months on their minimum and they're out on parole for 6 months, anywhere during that parole period, if they violated, the judge could say, I'm recommitting you for 6 months. It's not a sentence of 6 months, it's simply a recommitment. That offender basically owes 6 more months on their sentence. A judge could always re-parole if they wanted, but the person has to be recommitted for the balance. That works the same with state sentences, which we're going to cover here next. So when we're looking at confinement sentences, and we're going to deal with the typical min-max because that's the majority of confinement sentences, the maximum term of any confinement sentence will determine 2 things. It's going to determine who paroles the person, and it's going to determine where is that person housed. So we're looking at either state correctional facilities or county jails. So any confinement sentence where the max is 2 years or greater, so anybody that's sentenced where their maximum starts at least 24 months or more will presumptively always go to a state correctional facility, and the Board of Probation and Parole will have paroling authority over those individuals. Anytime the court imposes confinement and the maximum is less than 2 years, so it could be 24 months minus a day, some counties do 23.5 months on the max. If the court imposes anything less than 2 years on that max, it is always considered a county sentence, and the sentencing judge has paroling authority over those. So only on confinement sentences, that 2 years is the demarcation on the maximum to determine county sentences versus state sentences. So the way the law is since November of 2011 forward, meaning offenders had been sentenced starting in November of 2011 and forward, the place of confinement will always be equal to who has paroling authority. There are some exceptions to this designation in statute. One of them is DUI. There are certain DUI offenders, and these are DUI offenders who fall in the highest tier, meaning they have the highest blood alcohol or refusals, or they have subsequent DUIs. They're very specifically laid out in statute, where the judge has to impose the statutory max on some of these DUIs. The statute does permit those maximums that have a 5-year to be served in a county jail. If they're served in county jail, it's a county sentence. The sentencing judge can parole them. County parole supervises them. So that's one exception. The second exception to the place of confinement rules is what is the county jail's rated capacity. So depending on what your jail's capacity is, and that is a certification that is done by the warden of every jail. It's not anyone else. It's not the prison board. It's not the county commissioners. It's not the president judge. The statute specifically requires the warden to certify whether or not that jail is at less than 110% of its rated capacity. Rated capacity is defined in legislation. It has nothing to do with just simply total beds. It's a formula. So if your county is not under that rated capacity, anybody that is sentenced to a max of 2 years or more always has to go to state prison. But if the jail does meet under that rated capacity and it is certified by the warden, judges can sentence some people when their max is 2 years to less than 5. They can put them in county jail, but it would require the DA to be in agreement as well as the judge being in agreement. Keeping with confinement sentences, a couple other additional things that judges need to be aware of when imposing confinement sentences. When they're imposing sentences that would end up in a county jail, so meaning the maximum is less than 2 years, a judge cannot parole someone prior to the expiration of their minimum term unless at sentencing the judge said that offender was eligible to participate in a county reentry plan. Reentry plans vary from county to county. Some counties, it's simply their earned time or good time program. So if it's sentencing, a judge imposed something like 6 to 12 months of confinement, and the judge said eligible to participate in reentry. And if that particular county's reentry program is earned time, and say it's a calculation that for every month somebody does not have any, I'll call it misbehaviors in jail, they could earn 5 days off. So if they got a 6 to 12 month sentence, if they successfully had their earned time, they might be paroled early at a 5 month. Okay, the sentence didn't change, but the judge could possibly parole early, but only if they stated eligible to participate in reentry. Some counties consider early parole, some do not. So that might be something you would want to think about when a judge is imposing confinement sentences that are to be served in a county jail. Keep in mind, though, that a judge can never parole early on a mandatory, specifically DUIs that are served in a county jail. Offenders must always serve the mandatory minimum in a county jail. Now, at the state level, there's something a little bit different that the judge has to think about when they're sentencing to confinement, and it's called Recidivism Risk Reduction Incentive, or simply RRI. RRI is really an alternative minimum, and it's when an inmate who is serving a term of confinement in state prison successfully completes all of the required programming while they're in state prison, and they don't have any misconducts while they're in the custody of the DOC. So it's essentially an earned time or a good time program at the state level, but they call it RRI. And that alternative minimum is a calculation of the traditional min. So for example, if somebody was to receive a sentence of 2 to 4 years of confinement in a state prison, if the offender is RRI eligible, the court would impose a RRI minimum. And on a 2 to 4 year sentence, the calculation turns out to be 18 months. Doesn't mean the person is automatically going to be paroled at 18 months at that RRI min. It just means they're eligible for an earlier parole if they successfully completed their programs. If they haven't, or if they have misconduct while in state prison, they will not be released at their RRI min. Then they would go to their traditional min, and then the Board of Probation and Parole would determine whether or not that person is even eligible for parole at that time. So who is eligible for RRI? Well, in statute, anybody who has a present or past history of violent behavior, so it's your current offenses, it's pending charges, and it's prior convictions, prior juvenile adjudications, and it's a lot of serious violent crimes. It also includes personal injury crimes. Offenders convicted or currently or in their past that have personal injury crimes are statutorily excluded from receiving a RRI. There was one amendment, though, to the RRI legislation this past year, and it does impact personal injury crimes. The personal injury crime statute didn't change, but regarding RRI, our legislature said that M3s, misdemeanor 3 simple assaults, would not disqualify someone from receiving a RRI. So still, all personal injury crimes would make someone ineligible, with the exception of a misdemeanor 3 simple assault. Okay? Obviously, Megan's Law offenses would disqualify someone, and there's a lot more out there. But the bottom line, RRI is intended for nonviolent offenders who could possibly be paroled early if they've completed everything that they're required to complete while in state prison. Now, a few other concepts related to sentencing. When courts are imposing multiple sentences, they're required under rules of criminal procedure to state whether sentences run concurrently or consecutively. Concurrent sentences are running at the same time. They're running simultaneously. Consecutive sentences, they're running back to back. You start one, and then it ends, and then the next consecutive sentences would begin. What happens when judges impose consecutive sentences and when they're confinement sentences? Aggregation kicks in. Aggregation is simply adding your minimums together and the maximums together. So for example, if a judge imposes on one defendant 3 to 6 months of confinement, and then on another count, on the same offender, imposes 3 to 6 months and runs a consecutive, those are automatically aggregated. So the person is now serving a 6 to 12-month sentence. Aggregation happens automatically. So you might hear that term from time to time. Credit is another concept. It's something else that judges must be thinking about when they're sentencing, particularly when they're sentencing on confinement sentences. Credit has to be awarded for any time that is considered custodial, meaning maybe somebody didn't make bail, so they've been held in jail pending conviction and sentencing. So that's primarily what is considered custodial, things that are an institution. Sometimes the appellate courts have ruled that time in residential or inpatient treatment facilities could be considered custodial, and sometimes they do award credit for those instances. But credit never actually changes the sentence. It just has to be applied to that confinement sentence. So keeping a very simple example of a court imposing a 6 to 12-month sentence of confinement, if that offender has 3 months of credit because they did not make bail, the court would have to apply that 3 months of credit, and you would apply it and deduct it from the sentence. So essentially, that person would get 3 months toward their minimum term, and then they could be eligible for parole after 3 months. So the sentence is still 6 to 12. The court is simply applying the 3 months of credit time to that confinement sentence. Credit is only applied when they're imposing confinement, and it's applied whether they're sending them to a county jail or a state prison. Now, also in Pennsylvania, we have mandatories. Our legislature has created mandatories, and it's easiest to think about mandatories in 2 groups, those that are automatic or those that require notice. The automatic mandatories, the vast majority fall under DUIs. There's also the crime of homicide by vehicle while DUI. It's also an automatic mandatory. But most of our mandatories require prosecutorial notice, meaning the Commonwealth or the district attorney has to give notice to the defendant prior to sentencing that they're seeking a mandatory penalty. District attorneys typically use these types of mandatories in plea bargaining, but that will vary county by county. If you're interested in a list of all the mandatories, what types of crimes mandatories could apply, and whether or not they require prosecutorial notice, we have several tables on our website at the Sentencing Commission that you can view whether they're notice, not notice, and the length of those mandatories. Now, in statute, mandatories must be satisfied or receive a confinement sentence. That is primarily the starting point for every single mandatory. There are a couple exceptions in statute. There's only 4 that we're aware of that the statute specifically says that these particular crimes, DUI being one of them, boating under the influence, driving under suspension when there's DUI related, that is a summary offense. And there's a crime that's called that when you're operating a vehicle that's not equipped with ignition interlock and somebody is driving under the influence of that, they all face a mandatory penalty, but statute does permit the courts to impose a county intermediate punishment sentence instead of a confinement sentence. Specifically with DUI crimes, or DUI offenses, it is limited to the person's first, second, or third time DUI. Once somebody hits a 4th or subsequent DUI, they must be sentenced to a term of confinement. County IP is no longer an option for the courts. So that was really some basic fundamentals of sentencing. What I'd like to do for the remainder of the time that we have is to go through some general overview on what the sentencing guidelines recommend. In Pennsylvania, we've had various sentencing guidelines since the early 80s. Currently, we're working with 7th edition guidelines. They became effective December 28th of 2012. The guidelines that actually apply in a particular case are determined by when the crime was committed. The date of offense is what determines the addition. So we are still seeing cases coming through now under 6th edition guidelines because they apply to crimes committed on or after December 5th of 2008 up to including December 27th of 2012. At some point in the future, the Commission is already working on some amendments to the 7th edition guidelines, and they hope to have those adopted sometime this summer that would become effective in the fall, but that is still tentative. Any crime that was occurred before April of 1988, guidelines don't apply. That's why you see a box around the first two editions. The Pennsylvania Supreme Court invalidated our guidelines, so there really is no applicable guidelines for crimes committed prior to those dates. So the Pennsylvania guidelines are really, their goal is to promote uniformity and fairness in sentencing. They're simply a recommendation for the court, where they're providing a proportionate sanctions for the court. The primary purpose of guidelines is punitive. We provide recommendations for incapacitation or confinement type sentences, but there are some rehabilitative programs and types of sentences that are built into the guidelines. But keep in mind they are a recommendation. Some have called them advisory. Courts have to at least consider them, but they don't have to sentence within the guidelines, but at least it's the starting point for the courts prior to imposing sentence. So courts are considering the guidelines when they're sentencing on felonies and misdemeanors. They don't consider guidelines on summaries and other types of things such as ARDs and any other pre-diversionary program. Guidelines also have some enhancements that are built in. They are part of the sentence recommendation. But there are times when a mandatory could possibly apply. Mandatories will always supersede the guidelines. So if the mandatory is harsher than the guideline recommendations, that will always be the starting point. The court could never impose a sentence that's less than a mandatory, but they could certainly impose a sentence that's greater than the mandatory. Now, what do the guidelines recommend? They're recommending a minimum range of sentences, or a minimum term. We don't recommend maximums. We leave maximums up to what the legislature has established based on the grading or the classification of the crime. But all of our recommendations are based on a combination of two components. It's the seriousness of the current offense, and we call that an offense gravity score. And the second component is the defendant's prior criminal history, and we call that a prior record score. Now, the offense gravity score is really our primary determinant. The commission assigns those numbers. They go from a 1 as the least serious type of crime, and they go up to a 14, meaning the most serious type of crime. So that's going to measure what the person is currently convicted of and going before the court on sentencing. So if you've ever seen our matrix, the numbers along the left-hand side from a 1 at the very bottom going up to the 14 at the top, you will see some examples, and I have some very high OGSs, and you'll see just to the right of that some examples of what those crimes might have an offense gravity score assignment. You'll see some violent crimes, some felony ones, and other types of crimes. As you look toward the bottom of the matrix, where OGS 1, 2, 3, 4, you'll see some more minor crimes and some misdemeanors. Now, the second component that the court needs to know in order to determine the guideline recommendation is the offender's prior record score. So that includes not only prior adult convictions, it does include some prior juvenile adjudications. Now, the prior record score goes along the top part of the basic sentencing matrix, and we have numeric prior record scores of 0 through 5, and then we have some other categories for very serious prior criminal histories that are called repeat felony offenders, or RFEL, and the most serious type of prior record score is a repeat violent offender. So those are the other types of prior record score calculations that the guidelines might provide recommendations. So once we know those two components, offense gravity score, prior record score, provides a range recommendation to the court. Everything on the matrix is within the standard range, aggravated range, or mitigated range. So if I flip back to the prior slide of the matrix, all the numbers you see in the green, yellow, blue, white, purple, those are all standard range recommendations for the court. And the column to the right in orange are our aggravating and mitigating range recommendations. If the court does not impose a sentence within the guidelines, meaning it didn't fall within standard aggravated or mitigated, it's considered a guideline departure. For the most part, statewide, courts impose sentences within the guidelines, what we call conformity rates. About 90% of all sentences fall within standard aggravated mitigated. Approximately 10% of sentences imposed statewide depart from the guidelines. If you're interested in your county's conformity to the guidelines or how judges sentence related to the guidelines, that information can be found on our website in our annual report. Now, when you're thinking about those standard ranges or looking at the standard matrix, there are different colors on there, and those ranges or colors are recommending certain options for the court, and they're designated by levels. So, for example, if you look at the very bottom of the matrix in the corner, you'll see level 1, the purple cells. What level 1 is really suggesting to the court is non-confinement. So that would mean the guidelines recommend probation. The guidelines could recommend fines, restitution, or possibly guilt without further penalty. When you move up into the middle of the standard matrix, where you see blue and yellow, level 3, level 4, guidelines are primarily recommending confinement. It might be confinement in a county jail. It could possibly be confinement in a state correctional institute. But that's where now the courts could consider sentences in lieu of confinement, perhaps county IP, perhaps state IP in those areas if an offender is eligible by statute. Level 5, the green area, those are the most serious offenders, the most violent offenders. The guidelines primarily are recommending confinement sentences in a state correctional facility. Now, what the Commission has done under Level 3 or 4, since that's primarily the area that we would target for county intermediate punishment, there is some requirements that the court do prior to imposing county IP if they're thinking about that in lieu of confinement. And the biggest requirement is that they order a drug and alcohol assessment prior to sentencing, because the drug and alcohol assessment is going to determine whether or not that offender should require any type of treatment. The assessment tool in Pennsylvania that's used will determine a level of care, meaning does this person need inpatient treatment, do they need intensive outpatient treatment. There's various levels of care, and it will also suggest a length of stay. So the court should be following that recommendation if an offender is drug or alcohol dependent. If they're not, whatever the standard range for recommended confinement would be a day-for-day trade-off to a day in restrictive intermediate punishment program or programs. Some counties divert level 3 and 4 from confinement sentences. There are many counties that do not divert level 4, that simply the courts will impose a confinement sentence and not entertain county intermediate punishment at level 3 or level 4. Now, another recommendation that the Sentencing Commission has built into our guidelines, into our recommendation, are for enhancements. Don't confuse enhancements with mandatories. Enhancements are a component of the guidelines, meaning that if the facts of a case support certain circumstances, one of them might be when a deadly weapon is either possessed or used. If the facts say that, the court says yes, then the court could apply a sentence or impose a sentence based on our deadly weapon enhancement. There's definitions for possessed, different definitions for used. specific definitions for what is considered a deadly weapon. If so, the court would not be using the standard matrix. We have enhanced matrices when deadly weapons are used or possessed. The Commission also has an enhancement called a youth school, and that's when really there's 3 separate enhancements in our current guidelines. There's a youth enhancement when somebody distributes drugs to a minor. There's a school enhancement when someone distributes drugs within a school zone. And there is a youth school enhancement when someone distributes drugs to a minor within a school zone. Once again, these are not mandatories. There's mandatories that have very similar definitions, but they're differently applied by the courts. Enhancements are simply a component of the guidelines. The final program or recommendation that's built into the guidelines that I wanted to mention is the State Motivational Boot Camp. And the State Motivational Boot Camp is simply a program that the court would authorize an offender to participate in while they're serving their sentence in a state correctional facility. It's not a direct sentence by the court. The court would simply be imposing a term of confinement in a state correctional facility. There are limitations in statute, meaning that the court sentence would have to be 3 years or less on that minimum. So if a judge was going to be imposing a sentence of 4 years to 8 years in a state prison, they could not authorize boot camp. Similar to some of the eligibility in county intermediate punishment, state intermediate punishment, and the RRI statutes, in the boot camp there is a specific limitation on eligibility. Violent people cannot participate in the boot camp. It's intended for nonviolent offenders. And the offender would have to be eligible under the sentencing guidelines. The defendant would have to be under 40 years of age. That's a recent amendment in statute. It used to be 35. And the offender could not have any history of violence or escape. So it's not only what they're currently convicted of, is do they have any history of violence in their past. So the judge makes the authorization. The inmate gets sentenced to prison. They're serving a term of confinement. And the Department of Corrections, when they're classifying or screening that inmate, they look at the eligibility and they would give the green light if the offender can go to the state boot camp. The third thing that has to happen, though, is the inmate has to apply for admission. The boot camp is a voluntary program. So if the inmate does not want to go to boot camp, they can't be forced to go. Why would an inmate want to participate in the boot camp? Well, it would really allow them to be paroled earlier. The boot camp is a 6-month program, and if a boot camp participant successfully completes the program, when they graduate, they are automatically paroled. So what it does, it would reduce the amount of time they're incarcerated. On average, graduates from boot camp have reduced their sentence by 16 months. If they don't successfully complete the boot camp program, meaning they drop out or they are removed from the boot camp by the Department of Corrections, they must go back to their home institution to serve out their sentence. And then that would be up to the Board of Probation and Parole whether or not they would parole that offender. Now, a few other things that I want just to mention before we close out is that the Sentencing Commission is required to develop new guidelines for county parole and state parole, as well as resentencing guidelines when an offender sentence of county IP, state IP, or probation is revoked, because currently our sentencing guidelines only apply to the original sentence. So if a judge revokes any of those and resentences, a judge can do whatever they want with that offender within the parameters of the law. We're also going to be required to develop recommitment guidelines recommitment ranges, I should say, that the Board of Probation and Parole would be following when they're recommitting an offender following a state parole. And finally, what's really the Commission has been working on more recently is the development of a risk assessment tool that would be used by courts at sentencing. So we would be incorporating that in. The judge would know, for example, whether this might be a high-risk offender or a low risk, and factor that into their sentence. There have not been any deadlines in statute for the Commission to develop any of these, and we are working on all of them sort of simultaneous, but the development of a risk assessment tool is pretty much there's several interim reports posted on our website. Feel free to go out and check the status of that. We might be doing some testing later on this summer into the fall, specifically in counties, on the use of a risk tool. But you can go out to the Sentencing Commission's website, and there's a lot of information contained in our 2011 annual report. We're currently working on the 2012 report. That should be posted in July of this year. We have a lot of research projects posted on our website. If you're interested in, as I said earlier, the SIP or RRI information for a specific county, they're out there. All of the interim reports related to the development of our risk assessment tool. We had a huge 500-page research evaluation on the use and impact of mandatory minimum sentences. That was completed back in 2009. In addition, all of our Commission's newsletters are out there. So if you have any specific sentencing questions that you want me to work on for the Part 2 session, feel free to email me those. My contact is on the last slide here. You'll see my email address at hjp3@psu.edu, or you can reach me at my office. I work in the Harrisburg office, and I will certainly be more than happy to incorporate specific issues or questions that you may have. I did not see any questions scroll on the Q&A submitted by the participants, so I'm going to assume there weren't any. And with that, I guess I will turn it over to Heather on the appeals section.
Okay. For all you still listening, my name is Heather Gallagher. I am the Chief of Appeals in Lehigh County, and I was asked to talk to you a little bit about the appellate process and what happens specifically on appeals. In preparing for this, and each time that I've talked about this, I try to include something about my experience with regards to victims and victims' families, and sometimes the appellate process can be very confusing to them. Many of them are surprised by the length it may take, and some don't realize what the process is, and the fact that after somebody has been sentenced and is sent to either a state prison or the county prison or some kind of diversionary program, that does not necessarily end the process at that time. So I tried to include as much as I could about the process, and again, if anybody has any questions, if you type them up, I'll try to answer those as we go throughout. You just had quite an in-depth learning experience about sentencing, and so I'm just going to touch on that because really that's where the appeal process will begin, is right after sentencing. And after the defendant's convicted, obviously a sentence is imposed. That'll have a minimum term and a maximum term, as you all just learned. What happens after sentencing, though, is really where the appeals process starts to become involved. After the defendants are sentenced, they have an opportunity to file what are called post-sentence motions, and these are under the rules of criminal procedure. Now, they only have 10 days to file these after they've been sentenced, and typically in those motions, it sort of gives us an idea of what kind of things they intend to raise on appeal. And if they file a post-sentence motion, that's usually a sign to us that they do intend to appeal. Typically, what you'll see in the post-sentence motions usually are they may just be challenging their sentence. They're unhappy with the minimum term, the maximum term, or the manner with which the court ordered them to serve their sentences, either concurrently or consecutively. Sometimes they challenge maybe the weight of the evidence. If it was a jury trial and evidence and testimony was presented to the jury, they're challenging that testimony. They're challenging saying it wasn't strong enough to really convict them. Sometimes, although this has changed a lot in the last 10 years, they will challenge the effectiveness of their attorney. They will raise allegations that their attorney made certain mistakes or their attorney made certain errors or didn't do or did things they should or should not have done, and somehow that affected the outcome. It either made them have an unfair trial or maybe it resulted in their conviction. And then one other area that you might see a post-sentence motion filed for is a claim of after-discovered evidence. This could be anything from a new witness to new evidence that they've discovered, a new claim. I've had recently a case where a witness that testified wrote a letter recanting their testimony saying, no, what I testified to in front of the jury wasn't true. Sometimes it may be they claim that they had some deal in place and that's why they're testifying. Now, the court has 120 days to decide those post-sentence motions. Typically in Lehigh County, what will happen is often the judges, upon receiving those post-sentence motions, they'll have a hearing. Sometimes those hearings may be for witnesses to testify, and especially in the cases of an after-discovered evidence or ineffective assistance of counsel type of claim. Sometimes it'll just be to hear argument by the attorneys on the certain legal issues that are raised in the motions. If the judge does not have a hearing, again, they have 120 days to decide what to do. If they make no decision in 120 days, it is determined to be denied for purposes of law. Or the judge, after the time of the hearing, may then choose to deny it or grant it. Now, depending on what the claims are, if a motion is granted, it could go back for something like resentencing. It could even go back for a new trial if there was something, some error, a trial error or an evidence error that warrants a new trial. That obviously is very, very rare. Typically what happens is those motions get denied. Sometimes the defendant may be resentenced, and then the appeal process starts. What happens after those post-sentence motions, and the reason a lot of them are filed, is in order for the defendant to raise certain claims on appeal, they have to do what's called preserve them in the lower court. In other words, the court's got to explain why they ruled a certain way so that the appellate court can review it. So what will happen is the defendant, after the post-sentence motions are denied, is the defendant has an opportunity 30 days to file a notice of appeal. That is filed in the Court of Common Pleas. And really that triggers, that notice of appeal is what triggers now the appellate process. Now the case will move up to Superior Court. Now I can tell you typically what happens in our office is when an appeal has been filed, in most cases, certainly when it's been a violent crime, in homicides and burglaries, in most cases felony cases, as well as some misdemeanor cases and domestic cases, we will inform the victims. A letter will go out to the victims or their families informing them that a notice of appeal has been filed and that is the next step of the process. Oftentimes after that notice of appeal is filed and the letter is sent out, we will receive phone calls from the families or from the victims asking what is going on, what are they complaining about, what's going on. And a lot of times at that point, we don't know what they plan to complain about on appeal, because all the notice of appeal really requires is them to say, I'm appealing, and that's really it. What happens next is the court is going to typically, and they're not required to do this, but typically they will, is order the defendant or their attorney to file what is called a concise statement of matters complained of on appeal. The defendant will then have 21 days to file this. Now, the defendant in Pennsylvania is entitled to an attorney on their direct appeal, which is the process we're talking about right now. So they're entitled to that attorney during trial if that attorney continues to represent them through sentencing and through filing of the notice of appeal. That attorney will continue to represent them throughout the appeal, and that is the entire time that they are in Superior Court, as well as if they go to the Pennsylvania Supreme Court and thereon. So what will happen is after the what we call the Rule 1925B is ordered, the defendant will file that saying, okay, these are the issues that I intend to raise on appeal. Now, those issues, sometimes they may file multiple issues, and those may not necessarily be the issues. They may condense them then once they actually get into Superior Court. But the reason that they file this is supposed to tell the judge, the trial court, what I'm planning to raise on appeal. And then based on that statement, the trial court will file an opinion based on that statement explaining why the defendant should or should not be entitled to any kind of relief by the Superior Court on appeal. A lot of times the purpose of this is to explain why the judge ruled a certain way, maybe why the judge sustained an objection, why the judge overruled an objection, why the judge didn't allow certain evidence in, or why the judge did allow certain evidence in. Really, it's to explain how the judge exercised his or her discretion in order to let the Superior Court know why they ruled the way they did. Sometimes it's to explain, that they just felt that a witness was more credible or less credible, which is for the trial court to make that determination. So really that's what the trial court's opinion is for. It's just to explain why they ruled certain ways and how they viewed the evidence and the legal grounds that it may be sufficient, or why they sentenced the defendant a certain way and what they took into consideration when imposing that sentence. So once all that is filed by the judge and the judge files his opinion and all the transcripts have been transcribed, the lower court, the court administrator, will then forward the entire record, which includes all the transcripts, to the Pennsylvania Superior Court. What typically happens is the judge will certify the record, meaning the judge will say everything in the record is correct, all the transcripts have been filed, the record is complete, this is the entire record of the case for the Superior Court to review. Many times, depending on what kind of claims there are, that will include the evidence that was presented in court. It will include, like I said, all the transcripts, any motions that were filed, anything that was presented at sentencing. All of that will be in the court file, and that will be sent up to Superior Court. Once the Superior Court receives all of the record, they will then issue a briefing schedule. Typically, the appellant, who is whoever had filed the appeal, in many cases that's the defendant, they will have 30 days to file their briefs. I will say that extensions are granted pretty liberally. Sometimes they might ask for an additional 30 days. Sometimes they might ask up to 90 days. The Superior Court will grant those pretty liberally. Sometimes they will no further extend and say, nope, you're not getting any more extensions. You need to file it by a certain date. But as you can see, the time starts adding up. And so oftentimes, briefs won't even be scheduled, and we're talking 6 months after somebody has been sentenced. So it can be a lengthy process. Once the defendant files their brief or the appellant files their brief, then it's up to the appellee or the Commonwealth to respond. And this is typically, for me as Chief of Appeals, this is typically where I get involved, is once they have filed their brief, the file comes to me, and at that point in time, I will review all the claims, get all of our records, put that together, and prepare to respond to the brief. Every now and then, the Commonwealth will be the appellant. And this can happen every now and then during trial. It can happen post-trial. It can happen after sentencing. It's when we want to complain about something that happened at the trial, such as evidence being suppressed, or we are unhappy with the sentence that was given and we have legal grounds to appeal it. That doesn't happen as often. Typically, we are the appellee in these cases, and so we will file our brief in response to the brief that has been filed by defendant or defendant's counsel. And we will go through the same extension process that the defendant went through. Once briefs are filed, what happens is that there may be an opportunity to argue these cases. You could have standard argument, which is 15 minutes, expedited, which is 5 minutes, or you could submit the briefs to the panel without any argument, which is the most common way that the appeals are handled. They're handled on the briefs. When you argue, for me, for example, in Lehigh County, typically I will do my arguments in Superior Court in Philadelphia. The court sits in Philadelphia, in Harrisburg, and in Pittsburgh. Every now and then they will travel. I noted that they are going to be at the University of Pennsylvania in a couple weeks. A few weeks ago, they were in Northampton County. So every now and then they will travel to another county. I've argued in Carbon County as well as Dauphin County, not at the Superior Court where they typically sit in Dauphin County. But so that every now and then they will travel to another county. But for the most part, you're regularly going to either Philadelphia, Harrisburg, or Pittsburgh. Now, what I try to do when I'm going to have an argument, and it is one of the more serious crimes, we notify the victims or the victims' families in case they wish to attend the arguments. And those arguments will occur in front of a 3-judge panel. Now, there's no testimony taken. There's no evidence being presented. It is strictly the attorneys standing before the judges, presenting their arguments and answering questions from the judges. And like I said, they can be anywhere from 15 minutes to 5 minutes. And it's both sides gets that amount of time. Whoever has the appeal goes first, and then typically the defense attorney goes first, and then the Commonwealth of Prosecution will then respond to those arguments, and then the defense will have an opportunity to rebut those arguments. But most of the time what it is you're focusing on a single issue, every now and then 2 issues, and you're trying to focus in on the legal questions that the judges may have. After argument, or if the briefs were submitted for the panel to review without any kind of argument, what will happen is then the decision will take anywhere from 3 to 12 months. The decision can be published or it can be unpublished. The more serious cases, or if it's a kind of a novel legal issue, those are the type of cases that typically get published. Most cases are unpublished, and we receive those by email anymore. Everything's becoming electronic these days, but we'll receive an email notification of the opinion. And in the cases that we've had a lot of victim contact or family contact, we'll notify them of those decisions and what has happened. And again, very rarely do you have a case where someone's coming back for resentencing or coming back for a new trial. It is very, very uncommon, but we're talking about a very long, drawn-out process, and this, mind you, is just till we get through the Superior Court. And this is only one step in the process. So once the decision comes down from the court, depending on how it comes down, the next process is requesting re-argument. This is not something that's required, but you can request re-argument with the same panel that decided the case the first time around, or you can request what's called en banc re-argument. and that's typically before a panel of 9 Superior Court judges. If re-argument is requested, what will happen is that the court will either grant or deny it. If they grant it, there's a couple things they can do. They can require new briefs if there's a certain issue they want you to rebrief or focus on, and they can ask you to re-argue, actually come before and present oral argument to them. Currently, of all the cases that I have one case that re-argument was recently granted in, and we did have to file new briefs. However, they have not ordered argument in that case. So we're sort of just in a wait and see. And that is a case where the trial occurred a year and a half ago. So the process, while it has improved in the last decade, it is still a slow process. Once the case has been finished by the Superior Court, we then go on to the Pennsylvania Supreme Court. In death penalty cases, those cases will automatically be reviewed by the Pennsylvania Supreme Court, and that's by statute. Those cases immediately go up. They don't go to the Superior Court. They automatically go right up to the Pennsylvania Supreme Court to be reviewed to determine that if the evidence was sufficient to support the verdict, and also to determine if the death sentence is in any way arbitrary. In other words, were there aggravating factors to support the death sentence, and looking purely at the legal grounds. And typically in the death penalty cases, there will also be plenty of additional issues that shall be raised. However, those are the two areas that the court must review. And again, that's an automatic appeal. The defendant does not have to file a notice of appeal. It would automatically be sent up to the Pennsylvania Supreme Court for review. All other cases, the defendants have a right to an appeal in the Superior Court. They, however, do not have a right to appeal to the Pennsylvania Supreme Court. If they request such appeal, the attorney has to file one, and what they would file is a petition for permission to appeal. In other words, it's discretionary. So once the Superior Court decides their case, if they decided against them, then they would have 30 days to file this petition. And in this petition, what they're doing is they're asking the Supreme Court to take a look at what the Superior Court decided and what the trial court did. This can be granted, this can be denied, and usually that takes about 2 to 6 months. I currently have one case where the Supreme Court did grant what we call aliquotter. The defendant lost in Superior Court on a sentencing issue, and the defendant filed for a petition for permission to appeal. And approximately 6 months after he filed that petition, the Supreme Court granted it. It's in the last 4 years, it's only the second or third petition that has been granted compared to the hundreds that have been denied. So what just happened is we received, because it's been granted, we received a new briefing schedule. And in fact, the defendant's brief is due in another 2 weeks. But I wouldn't be surprised if he doesn't file an extension petition asking for additional time. Now, on direct appeal, when they grant aliquotter, what we call aliquotter, which is the granting of that petition for permission to appeal, they will then set up for oral argument. Sometimes they can go ahead and decide them on the brief, and that is their decision. We have no right to request argument, to say, no, we don't want to argue. It's really up to the Pennsylvania Supreme Court. And typically, if they have granted a petition for permission to appeal, they're going to want to have argument, in my experience. It's very uncommon for them to just decide it at that time based solely on the briefs. If it is argued, then you're looking at another 6 to 23 months before you get a decision. If they deny the petition for permission to appeal, then you have 60 days to file a writ of certiorari in the United States Supreme Court. That happens in a handful of cases. It's very uncommon. Again, it's not required by the attorneys, so it doesn't happen very often. Permission to appeal, I just have a question. Is permission to appeal given only in the state Supreme Court? Yes. What the state Supreme Court, when you file the petition for permission to appeal, you're asking for them, for the state Supreme Court, to review it. They'll either deny or grant that, as I said before. Then you would file, it's basically the exact same process in the United States Supreme Court should you choose to go that route after the state Supreme Court has either denied your appeal. And that's called a writ of certiorari, which they will either grant or deny. I have never had a writ granted. They've always been denied, and usually they're pretty quick to do it. Now, I will say in the last 2 to 3 years, the Pennsylvania Supreme Court has issued new, what they call internal operating procedures to try to speed up the process. They recognize how drawn out the process takes, and certainly in capital cases, death penalty cases, and some of the more serious and lengthy homicide cases, the process is dragged out. So they've issued an internal operating procedures to try to speed up that process, and really it's on their part. They've set up guidelines that once a petition for permission to appeal is received, they will have a decision within so many days. It will circulate through the judges. If it's granted or if it's a death penalty case, within so many days after argument or so many days after briefs, whoever's been assigned, whatever judge has been assigned it, will have a bench memo or to all the other judges. So they're trying to speed up the process. I will tell you, however, currently I have a matter that I argued in the Pennsylvania Supreme Court. It will be 2 years ago this June. And that is a direct appeal after post-sentence motions were filed and decided the person was sentenced. It's direct appeal, and it's been 2 years since it's been argued, and I'm still waiting for an opinion. So unfortunately, with some cases it takes a long time. Some cases it is quicker, but it can be a very long, drawn-out process. Unfortunately, just when you thought it was over, it's not. We have in Pennsylvania what's known as the Post-Conviction Relief Act. The Post-Conviction Relief Act basically is the next set of appeals, or the next step in the process. In order for someone to be eligible to file a Post-Conviction Relief Act, and it's called a petition, they have to be serving a sentence of either imprisonment, probation, or parole. So they have to be serving some kind of a sentence. Now, these petitions, typically they have them in the prisons. These petitions are filed then with the same court and assigned to the same judge that heard the trial the first time around. This happens after their direct appeals are completed, or if they chose not to file the direct appeal and to go straight to what we call the PCRA, it is again filed in the lower court or the trial court, and the same judge that heard the case will be reviewing this. Now, the PCRA, unlike direct appeal, which is pretty much open to everything that involves trial court error or any challenges to evidence and so forth, there are very specific areas that they're challenging when it comes time for their PCRA petition. Only these issues can be included and can obtain them some sort of relief. The first one's a constitutional violation that undermines the truth-determining process, such that no reliable adjudication of guilt or innocence could have taken place. This could be a Fourth Amendment, a search and seizure type of violation, and it has to have been preserved somewhere. The most common claim for relief, or the most common complaint that you see, is ineffective assistance of counsel. what they're doing is complaining that something that their attorney did caused them to be convicted, caused them to get the sentence that they did, and they're asking for relief. Now, an ineffective assisted counsel claim, if they are successful in that, that would obtain them a new trial. Another claim for relief is that their guilty plea was unlawfully induced. If the defendant pled guilty, they're saying that it was not knowing, it was not intelligent, it was not voluntary, or that their attorney coerced them, somebody coerced them into pleading guilty, that they're really innocent, or that they just didn't know what they were doing. Improper obstruction by government officials of the right to appeal. As I previously stated, the defendants do have, once they've been convicted, they have the right to file an appeal in the Superior Court. If they've requested one and their attorneys don't file one, that's a claim for relief under the, you would file a petition under the Post-Conviction Relief Act requesting a new appeal, saying, I didn't get my appeal, I asked my attorney to file the appeal, the attorney didn't do so. Typically in those cases, they're going to get their direct appeal. Another claim for relief is that they've discovered some new evidence that would have changed the outcome of their trial if it had been introduced. Now, the outcome of their trial doesn't necessarily mean that they wouldn't have been found guilty, according to them. Sometimes it can be that the trial was not constitutionally fair, that it was, you know, a trial by ambush, or there was some kind of evidence that was hidden that would have maybe affected how they would have handled the entire trial. And it's of such importance that a new trial should be granted. Another claim for relief is an illegal sentence. That can be a sentence that maybe exceeds the statutory maximum, or in some way is illegal, that a mandatory sentence was imposed and it should not have been. Where they would complain about this is under the PCRA. Now, what will happen is, first, is that the defendants will file typically a pro se petition. Usually they don't have counsel at this point, and so they will file their petitions themselves. This is a form petition. They have them at all the prisons, and it's just a fill-in form. They file that with the lower court. Now, once they file that with the trial court, they are, in Pennsylvania, entitled to have an attorney. So they will get counsel appointed, once again, to review their petition, to review the record. They should get in contact with the defendant to discuss with them, make sure that they know what kind of complaints, what their complaints are. And then based on all of those, the attorney will determine, okay, do I think that there's some merit or some arguably meritorious claims? If they think that, then what they'll do is they'll file an amended PCRA petition. This amended petition is essentially encompassing what the attorney discovered based upon their review of all the records, talking to the defendant's pro se petition, and putting that in a petition format. If after reviewing all of that stuff, the attorney determines, look, this is frivolous, there's nothing here, everything is fine, they will do what's called a no merit letter, which is saying that I've reviewed everything, there's the issues that defendant wants to raise have no legal merit or no factual merit, and therefore the attorney is asking the court to dismiss the petition and to let the attorney out of the case. Now, here in Lehigh County, often after these Finley letters or the amended petitions are filed, if it's a Finley letter, no merit letter, the court will just review the case. They'll issue a notice, we call it a 907 notice, and that's because it's Rule of Criminal Procedure 907, notifying the defendant of their intent to dismiss the case. And then letting the defendant know in 20 days we plan to dismiss the case, we don't think it has any merit, you can respond if you want, and then the court will dismiss it. If an amended petition was filed by the attorney said, look, after reviewing it, I think that there might be something to this, or at least I think we need to kind of flesh it out a little bit. The court can either review it based on what's been filed, could ask sometimes the prosecutor to file a response, or they'll have an evidentiary hearing. Oftentimes here in Lehigh County, the judges automatically schedule those for evidentiary hearings. At the evidentiary hearings, witnesses can be presented. Sometimes it's just argument, but the defendants will be present for those. Many times, if it's a claim that counsel the trial attorney was ineffective for one reason or the other, say not presenting certain witnesses, the defendant may present those witnesses at this evidentiary hearing. Sometimes the prosecution will present their trial attorney to say, no, I did all this, I didn't do this, this is why I didn't do this, I didn't think it had any basis, but it will be a hearing. I will tell you, sometimes PCRA hearings can be longer, or at least as long as the trial. And that's definitely true, unfortunately, in death penalty cases. I currently have one of the death penalty cases that I am working on. The trial itself lasted, I believe, 8 days. The PCRA hearings have lasted 4 weeks. It's a shame, but when they're bringing in tons of witnesses and tons of allegations and the judge is not restricting it, it can last that long. Now, what we have done in Lehigh County is that we've developed a letter that we're trying to send out, that we plan on sending out to everybody for the PCRAs when hearings are going to happen. And at the present time, I do know that families of homicide victims and more serious crimes are notified by phone to let them know. And the reason for that is many of them don't realize that the defendants themselves are going to physically be in court for those hearings. And many of them may want to be there and may want to be present. And if it's not to appeal that they're getting a notification letter, oftentimes I know that we'll get questions, well, you know, once they've received a letter that the defendant's filed an appeal, they'll ask, well, if he's going to be in court, I want to be able to be there. And most of the time on appeal, there is no presence in court. Nothing's going to happen in court. It's all going to be done on paper. In Lehigh County, at the very least, when PCRA petitions are filed and an amended petition is filed, the court's going to have a hearing. And at those hearings, the defendant's going to be present, and he's going to be at those hearings, and the trial attorney is going to be at the hearing again. And sometimes the victim's family or the victims themselves may want to be present for that, just to see them or just to hear what they have to say. So we're trying to improve the process and have them present and notify them. Certainly in homicide cases and definitely in death penalty type cases, we always stay in contact with the victims' families to let them know what process and what's going on in the case and where we are in the case. And it's, as I said, it's often a frustrating, long, drawn-out process. But once the court does a hearing, after reviewing the evidence from the hearing, they may order both sides to file briefs addressing the legal issues, and then the court's either going to grant or deny the PCRA petition. If the court grants the petition, then they're either there's a couple different things. They're granting the person a new trial. If it's a claim of ineffective assisted counsel or newly discovered evidence or something of that nature, they're going to grant a new trial, and then the process starts all over again. If it's a situation where the defendant pled guilty, they'll allow them to withdraw the guilty plea, which again starts the process all over again. Sometimes if it involves sentencing, it could be a new sentencing hearing. Sometimes if it's a claim that they wanted an appeal and none was taken, it could just be a brand new appeal. I have a question coming up, so I'm just going to read that real quick. During PCRA, and from the prosecution perspective, what, if any, attention is paid towards increased restitution due to additional expenses directly related to crime injury and borne by the victim? At this point in time, typically the expenses, if there's additional expenses for restitution purposes post-sentencing, then that's always something that can be addressed with the defendant and the court. Additional expenses directly related to, like you said, the crime injury borne by the victim. It doesn't matter on PCRA. It doesn't matter at what stage of the game it is. Restitution is something that can always come back and be addressed. It doesn't have to wait till PCRA, and I believe under the rules, as long as the defendant's provided notice, it's something that can again be addressed if there's additional injuries or things that come up. And what you need to do really is notify the prosecution, notify crime victims counsel, or your advocates at the district attorney's office to let them know about that. That's something, again, can always be addressed with the court. It doesn't have to be limited to the PCRA context, and you don't have to wait till the PCRA in order to address that. It's something that we can always address and try to address with the court. As far as PCRA is concerned, a lot of times the families, you know, they may not want to come back in. They don't want to have to redredge it and bring it up again. But they want to know what's going on. And so we do try as best that we can to provide them with that information. Now, once the court, if the court ultimately denies the PCRA petition, which is what happens in most cases, it'll go through the same appellate process or appeals process that happened on direct appeal. It'll go to the Superior Court first, but if it's a death penalty case, again, it will automatically go up to the Pennsylvania Supreme Court. They have exclusive jurisdiction on appeal for those types of cases. All other PCRA appeals will go and follow the same procedure in Superior Court that the direct appeals did. The only difference is PCRAs, whether it be in the Superior Court or in death penalty cases in the Pennsylvania Supreme Court, there is no argument on those cases. So the court does not even entertain arguments. So there won't be any opportunity to go before the court either in Philadelphia, Pittsburgh, or Harrisburg to present an argument on those cases. Now, there is some light at the end of the tunnel, and that is the PCRA time bar. What this says is within 1 year that a defendant's judgment becomes final, the court no longer has jurisdiction to review anything sent to them. Now, this does not stop defendants, particularly if they're serving a lengthy sentence, from filing things and appealing things and constantly filing and appealing things. But the way the statute is written and the fact that the court has no jurisdiction really is a huge thing, because what that means is for the judgment to be final, that means 1 year from when the direct appeals basically ended. So if the Superior Court decided the direct appeal and they didn't file a petition for permission to appeal to the Pennsylvania Supreme Court, 1 year from that date, they have 1 year to file the PCRA petition raising all of those claims for eligibility that we reviewed before, the ineffective assisted counsel, the induced guilty plea, the illegal sentence, the newly discovered evidence. All of those things must be raised within 1 year of when that sentence or when that judgment is final, 1 year from the end of the direct appeal. If they don't file that, or if they file their first PCRA within that year, you know, then this is a second PCRA petition. The court no longer has jurisdiction to even look at it. And what that means is the court won't even consider the merits. The court won't even review the merits of the claim. If it is a second PCRA petition, as I mentioned before, in Pennsylvania, they are entitled to an attorney with their first PCRA petition. If it's a second PCRA petition, they are not entitled to an attorney, and so they will be doing it all on their own. Now, there are 3 exceptions that will get them over the whole hurdle of jurisdiction. The first one is government interference. In other words, the government hid evidence that prevented them and they didn't know about it, and so they couldn't raise this claim any sooner. Newly discovered evidence. They just discovered some new ballistics evidence or new blood evidence that wasn't present the first time around. Or they discovered, a witness has recanted or a new witness has come forward. That would be a newly discovered fact. Or a new constitutional right. Recently, we've been dealing with the new constitutional right, as I'm sure some of you or most of you should know. In June, the United States Supreme Court said that a juvenile sentenced to life, a mandatory term of life imprisonment without the possibility of parole, is unconstitutional. Pennsylvania is one of the states that allowed for mandatory life terms, life sentences, for juveniles convicted of first and second degree murder. I know every single such a juvenile in Lehigh County filed a PCRA petition after that case alleging a new constitutional right. Now, typically, as far as all of those juveniles in Lehigh County are concerned, if it wasn't for this new constitutional right, their PCRA petitions would have been dismissed as untimely because the court would not have had jurisdiction to consider them. However, because of this new constitutional right that the United States Supreme Court handed down, their petitions are being reviewed and the merits of those petitions are being reviewed. And currently in Lehigh County, they're stayed right now pending a decision we're waiting for in the Pennsylvania Supreme Court that has not been decided yet, that will affect all of the defendants, juveniles in Lehigh County. But that's an example of an exception, a case like that that comes out. That's not very common, but every now and then a case like that will come out that gives a new constitutional right. A couple years ago, there was a new constitutional right with regards to the death penalty that those individuals that are mentally retarded cannot be put to death. Before that, there were juveniles, that case that came down that said juveniles cannot receive the death penalty. So periodically there's a new case, new constitutional right that will be handed down by the United States Supreme Court that defendants will be able to overcome that jurisdiction hurdle, that time bar hurdle, and file a PCRA petition even though it's been more than 1 year after their judgments became final, and the court's going to now have to review. The trick is they have to file that PCRA petition within 60 days. In other words, 60 days from the date that the new constitutional right was given. In other words, 60 days from the date that the U.S. Supreme Court decided the case saying that juveniles could not receive a mandatory life sentence without the possibility of parole. They have to file it within that. Or it's 60 days from when they discovered or should have discovered this new evidence that they found. Or 60 days from the government interference. That is a strict rule, that's 60 days. What the court has said and what the legislature has said is that's enough time. The defendant has to be diligent. In other words, before this PCRA time bar passed legislation, which was in 1996, you could just keep filing PCRA petitions over and over and over again, lengthening out, and there was nothing to do to stop them. This is the legislature's attempt to limit it to those few cases that fall under these 3 exceptions rather than constantly reviewing petition after petition and having to review the merits of these claims. The PCRA process certainly can be long and drawn out. It doesn't get priority the way trial is done, nor should it. The defendants, for the most part, they aren't going anywhere. They're sitting in prison and they're filing the PCRA petitions or they're filing the appeals. And again, we often find in our experience it can be a frustrating process for the victims and the victims' families. They don't understand that it can keep going on and on. And we try to notify them unless they specifically request that they don't want to be notified every time an appeal is filed. Nothing prevents them from putting the paperwork in the mail to file the appeal, even when they've waived those appeals. And nothing stops them from filing a PCRA petition. All we can do is continue to defend the convictions, defend the sentences, which we do in the Superior Court and the Supreme Court. You know, and I didn't even touch on the federal appeals process, which they can do also, and they have a process to do, even though it's a state conviction. If they want to challenge a federal constitutional claim, they can do that in federal court, and it will go up through. And it's a much quicker process, certainly, and it's almost always done on paper there. And it's far less frequent than what happens in the state court. But this is the process that the defendants will go through in the state court. And so I've tried to, as best I could, give the timeline of how it goes and what happens and the process. But like I said, the case I mentioned to you about the PCRA, where the hearings themselves have lasted longer than the actual trial, you know, that's a crime that happened in the late 90s. And unfortunately, the case that I argued 2 years ago in front of the Pennsylvania Supreme Court that I'm still waiting for decision on is a crime that happened in 2004. So unfortunately, you know, it can be a drawn-out process. We do our best to streamline it and our best to get it through the system and be as supportive as possible, but I certainly can understand how frustrating it can be. That's really all I have, and I didn't get any more questions. I tried to answer the ones I have, but if anybody has any questions, please feel free, you know, to pop them up, and I will give you my email address and phone number if anybody ever has anything come up and wants to contact me. That's no problem at all. My email address is Heather Gallagher, and that's HeatherGallagher at LehighCounty.org, and Lehigh County is spelled out. My phone number is 610-782-3104. So if anybody ever has any questions about the appeals process, the PCRA process, and really what happens and how it goes, I'm always happy and always available to answer those. But that's all that I have. I know we finished a little bit early, but unless anybody has any other questions, I'm going to go ahead and sign off. No questions? All right, well, have a good day, everybody. Thank you.